Hi, my name is David Jolly and welcome to the video. This video is hopefully going to take you through the entire DUI process from the beginning until the end. I'll talk to you about what you need to do immediately following the arrest and release from custody, including court as well as your license. Through the entire court process, the licensing procedures, obligations you may have, and potentially the collateral consequences that may occur, such as employment or travel after an arrest for DUI. I'll focus on the following topics: licensing, including the Department of Licensing hearing, license suspensions, the ignition interlock device, restricted licenses, CDLs, and even driving a company vehicle. The court process, from your first court date to the final court date, and I'll also talk about negotiation, possible outcomes, motions, trial, and deferred prosecution. I'll also talk about probation and penalties and conditions that may be imposed by the court, including jail alternatives such as home detention, and in fact the one-day offender program, which is unique to Skagit County, and the scram bracelet, among other topics. I'll also spend some time on some things you may need to complete during the pendency of the case, and these include an alcohol drug evaluation, an ADIS class, the possibility of alcohol drug treatment, and the DUI Victim Impact Panel. Miscellaneous but important topics such as travel to Canada and employment will also be addressed in this video. And finally, how to select the right attorney for you. This is really important, and I'll have a chapter of the video dedicated to this. Now, much of this information can be found in my annual DUI handbooks, which are free and can be downloaded on my website. So, this video is long. It's intended to be long, but if you're here for one particular topic or section, feel free to fast forward or skip ahead to that section. And I have a menu in the screen now, and also I have the same menu or a similar one down below in the description. I don't specifically mention the crime of physical control too often in this video, but physical control is the same as a DUI, but for one difference. Physical control has no driving element, but every other element of the crime and penalties are identical. So when I say DUI, I'm also referring to physical control. Finally, while much of what I have to say deals with DUI law throughout the entire country, I'm really focusing on Washington law as that is where I'm licensed to practice. And even more specifically, I'll be giving examples from primarily Whatcom County and Skagit County, as those are the two counties where I practice, well, pretty much exclusively, and the location of both of my offices. All right, very quickly about my least favorite topic, me. I've been an attorney in Washington State since 1997. I was first a prosecutor in Kitsap County and then in Snohomish County with the City of Linwood. After about 4 years of being a prosecutor, I accepted a position at a private law firm in Snohomish County. And then about 4 years after that, I started my own practice in 2004. In 2007, I wrote my first DUI book and have written about 30 or so books on criminal defense and DUI since. And a couple of important things to mention before we jump right in. This video is not legal advice. This is information only. Every case is different. Every person is different. Every jurisdiction is different. So it's really important you consult with your attorney who knows your local courts, your case, and you. All right, it's been said that your defense starts the moment law enforcement contacts you, and this is actually very true. But this video isn't about that. This video is dealing with the DUI matter once it has already happened. So that being said, your defense starts the minute you've been released from custody. Now, this might mean when a law enforcement officer permits you to leave after they've arrested you and after the breath test, or when you're released from jail. In Whatcom County, the default practice is to book you into jail after you've been arrested for DUI and taken for a breath or blood test, while in Skagit County, their practice is to release you after the incident and not book you into jail, unless you have a prior DUI arrest, and then they probably will book you into jail. When you are released from custody, your first job is to review all of the paperwork that you've been given. Now, I know this is not really what you want to do, but it's really imperative. The paperwork will give you information on a future court date as well as the Department of Licensing information. If your case is a district court case, whether this be in Whatcom County or Skagit County, you could have court the same day or the next day. If you have a court case in a municipal court, such as Bellingham Municipal Court, you could have court the same day as well, but early in the morning, like at 9:15 a.m. So it's imperative that you know when the court is, because we don't want a bad situation like a DUI charge to get worse, meaning a DUI charge and a bench warrant for your arrest because you missed your court date. As for your license, if your BAC is over 0.08 or over 0.02 if you're under 21, or if you refuse the breath or blood test, you will lose your license 30 days after your arrest for DUI. However, you can contest or appeal this, but you must submit this request within 7 days of the date of arrest. And I'll discuss this more in the licensing section. Finally, at least for the first things to do after your release, talk to an attorney. He or she can give you some advice and information that might be immediately valuable and important. All right, well, let's talk about court. Now, for most people, court is the toughest part of the process. And the reality is court is tough. I mean, there's nothing like standing in front of a judge and being accused of a serious crime. And sometimes the unknown is a big part of the stress. So, well, let's clear some of it up and let's talk court. The first court date you will appear at, with very few exceptions, is called an arraignment. The arraignment is where you will be advised of the charge, the potential penalties associated with the charge, maximum and mandatory minimum penalties, your rights, and then you'll be asked to enter a plea, which is always not guilty. Then the judge will consider conditions of release. Conditions of release are essentially rules which you have to follow while the case is pending in order to stay out of trouble. Typical conditions for a DUI include do not drink or use non-prescribed drugs, including marijuana. Don't go to places where the primary business is the service of alcohol. In other words, don't go to bars. Stay out of trouble, do not commit any crimes, and appear back in court when you have to. Now, a quick word about these conditions. If you work at an establishment that serves alcohol, tell your attorney prior to the arraignment. It's important the judge permits you to go to your place of work in order to maintain employment. If this exception is not part of the judge's order, you will not be permitted to go to work. All right, well, look, there are times when a court will impose additional sanctions and penalties. These can include pretrial probation, which means you're on probation during the case, an ignition interlock device, a scram bracelet, or even bail. The court may impose such conditions if the facts of your case are particularly egregious, so in other words, a bad accident, a high breath or blood test, or if you have a prior DUI. Now, if you do have a prior DUI, you can expect, at least in the courts I'm in, pretrial probation, and in every court in the state, an ignition interlock device if the present and current case involves alcohol. An ignition interlock is mandatory, in fact, if you do have a prior DUI charge. If you don't have a vehicle to put the device in, well, then you'll need a scram bracelet instead. The next court date is called a pretrial. This court date is when a case can resolve or the case can be continued. A continuance is when we ask for more time so that we can gather more evidence, complete necessary tasks like an alcohol drug evaluation, prepare for motions or even a trial, and importantly, continue to negotiate the case. Now, depending on your case and the court you're in, it is likely you won't need to appear in court at a pretrial if you have an attorney. Now, this is true for all Whatcom County courts, including Whatcom County District Court and Bellingham Municipal Court, and all Skagit County courts, including Skagit County District Court. A motion hearing can be done for a variety of reasons, and depending on that reason, we might have some slight variations of the term. But to keep it easy and simple, I'm just calling this type of hearing a motion hearing. Okay, motion hearings are when we want to argue evidence in a case. Specifically, we want to try and suppress or remove evidence in your case. Successful motion hearings can remove or suppress evidence and even in some cases, dismiss the case. Typical motion hearings might include a motion to suppress the breath test, blood test, the refusal of a breath or blood test, probable cause to arrest, or even the original contact of the defendant or stop of the vehicle. Probably the most common motion hearing, though, is to suppress statements made by the defendant. Certain motions, such as suppressing a breath test, does not dismiss a case, but removes the breath test, which would certainly improve the case. On the other hand, there are motions that are what we call dispositive, which means they can dispose of a case, so dismiss the case. Such motions that are dispositive would include a motion to suppress the original stop or contact of a person, or that there was no probable cause to arrest for DUI. If your case has been negotiated to a place that's acceptable and you want to enter a plea, well, you have to go back to court and enter that plea. But you just don't show up to court unprepared. Now, I can't speak for all attorneys, but the way I do it is to prepare for the plea with my client at least a day before court, and of course, the day of court. When we appear in court, I always go over the plea with my client at least twice. The first time we go over a plea form is to ensure that my client understands what is in the plea form, what every paragraph means, the impact, of course, and the recommendations that are jointly agreed to. The second time we go over the plea form, I actually pretend I'm the judge, and I go over the plea form with my client exactly like a judge would. And the reason I do this is it prepares my clients for their appearance in front of the judge. Entering a plea is stressful, so my hope is that this removes a little bit of the stress from my clients. And importantly, the idea here is that there are no surprises. Surprises are not good. Now, after a plea, you may need to check in with probation. Of course, you may not need to, but that depends on the result of your case. But if you do, your attorney should prepare you for this. You may also need to check in with the court clerk to set up a payment plan, if in fact it hasn't already been done so in court. If there's jail time or home detention time, you will also need to contact the appropriate agency to schedule this. Now, I won't spend too much time in this video talking about trial, as I think that should be a separate video and is probably overkill for this video. But here is a synopsis of what a DUI trial looks like. First, most DUI cases never even go to trial. Second, when we do go to trial, this means, at least to me, that we have not successfully negotiated the case to an acceptable result. This is usually a disappointment, as I really focus on negotiating a case to a vastly improved result. And I'll talk about that during the negotiation chapter. Third, if the case does go to trial, well, this is a big deal. Trials can be stressful and time-consuming. And the basic idea of a DUI trial is that the government must prove that you have committed the crime of DUI beyond a reasonable doubt. Again, I won't detail the trial process in this video too much, but the government presents their case based on permitted evidence, and the defense offers a defense, or alternatively, argues that the government has not proven their case beyond a reasonable doubt. The presentation of evidence starts with the government and their witnesses. Their witnesses would include the officer or officers that were involved in the case, perhaps civilian witnesses, and even experts, such as a BAC technician and toxicologist. Now, once the government has rested, in other words, have had all their witnesses testify, well, it's your turn, the defendant's turn. Defense witnesses may include you, the defendant, civilian witnesses, and even your own experts. Once the case and evidence has been presented, the attorneys make closing arguments and then the jury decides your fate. As I said, a trial is usually, but not always, a last resort. If you believe you want to go to trial and you feel this way at the beginning of your case, be sure you discuss this process with the prospective attorney before you hire him or her. You want to know if your attorney is capable of taking your case to trial before you commit to hiring. Some attorneys don't even go to trial, while others might have a schedule issue or conflict at that time and may not be able to even do your trial in the next few months. And you need to know this before you hire the attorney. Negotiation is an integral part of every DUI case. The basic premise is rather straightforward. We want to negotiate to an improved result. We have to improve your case. Now, negotiation is a bit of an art form, which does sound a little bit pretentious, and honestly requires really years and years of practice to improve. For example, I'm a far better negotiator now than I was 25 years ago. Now, here are some of the things that I look for to help my clients with negotiation. First, and most importantly, the facts of your case. For example, if you were stopped because you had a headlight out, you were cooperative, and your BAC is, for example, around 0.09, then these facts support a reduction from DUI, presuming you have no prior DUI or related criminal history. On the other hand, if you're involved in the accident or had a child in the car or a firearm in the car, or you weren't cooperative, refused the breath test, or if your breath test was high, meaning over 0.15, it is likely that the government will be far less willing to consider a reduction from DUI. Second, criminal history. As I alluded to, if you have no criminal history, this makes negotiation far easier. If you have a prior DUI, well, this makes the case much harder to negotiate. I'm often asked if a prior DUI makes a case twice as hard to negotiate. No, it makes it 10 times more difficult to negotiate. Third, legal defenses. Okay, well, sometimes we do not have facts that help us. If your BAC is, for example, around 0.13 or higher, you will not get a simple reduction. That BAC is just too high in most courts for that desired reduction. Therefore, we need legal defenses. Now, there are many potential legal defenses, but we're looking for legal issues in, for example, the way you were contacted or stopped, probable cause to arrest, and the breath testing or blood process. If we're able to locate a solid legal defense, then we try and use this to negotiate your case to a better result. Okay, well, what if we don't have any good legal defenses? And yeah, this does happen a lot. Well, we just don't give up. Negotiating isn't just about finding something and then hoping it works. The truth is sometimes it doesn't work. And that's when we have to get creative. Now, this is probably a separate video, but in times like this, I try to barter with the prosecutor. Now, it might be giving up something to get something. So giving up something might be more jail, in other words, more home detention most likely, community service, or more probation. But whatever we can do to get a better result is worth exploring. However, and ultimately, it does have to make sense for you. Yet another important part of negotiating is telling a story. And this is part of every negotiation. Look, sometimes bad things happen to good people, and we want to share with the prosecutor important and compelling information about you. For example, have you had some difficult times recently? Or will this charge of DUI cause you severe consequences? Now, sometimes this information can make a difference in the outcome of your case, and honestly, sometimes it doesn't make any difference. But negotiating is about trying everything we can to get a better result, and you just never know. The human element can sometimes be the difference between success and failure, and is always worth trying. Okay, and finally, relationships. It is, at least in the smaller counties, so not King County perhaps, but most other counties, really important to have relationships with prosecutors. If the prosecutor knows your lawyer, trusts him or her, respects them, and even likes them, then the chance of a better deal is more real. Okay, well, now let's talk about penalties that might come from a DUI. And this is not the most enjoyable thing to talk about, but we need to. The amount of jail you get often depends on the facts of your case and your prior criminal history. If you have a prior DUI charge within 7 years, the penalties get severe. If you have 2 prior DUI charges within 7 years, well, things get even worse. Even if you have a DUI charge from 30 or 40 years ago, that will be used against you. Now, if you do have a prior DUI charge, please talk to your lawyer in more detail about this. All right. If the jail in your case is mandatory, and DUIs do come with mandatory jail, then it must be served in a jail. That being said, there are a couple of exceptions. First, you can convert jail to home detention, but the ratio isn't appealing. 1 day of jail that is mandatory can be converted to home detention on a 1:15 ratio. This means 1 day in jail is 15 days of home detention. Now, if you do get jail, you would need to report to the Jail Alternatives Office in Skagit County or the Jail Work Center in Whatcom County. In Skagit County, they have a great program that converts jail into their 1-day offender program. However, this must be negotiated. The 1-day offender program allows you to convert up to 2 days of jail. You would then serve the jail in a dormitory that's located on the Skagit County Fairgrounds. The Skagit County Sheriff's Office runs this program a few times a year, so you have to schedule your time in advance. Now, this isn't perfect, but I can tell you it's far better than going to jail. Work release is where you are actually in jail, but you're permitted to leave every day for work. Now, you should expect to have to tell your work that you're in the program, and you're not able to drive when leaving the jail. So you'll need to have someone pick you up daily. Home detention is where you serve your jail time at home. If you work, you are permitted to leave your home and go to work, and then return at the end of the day. The government-run home detention program in Whatcom County is pretty limiting in that you only qualify if you both work and live in Whatcom County. FDS stands for Friendship Diversion Services and is home detention. The difference is it's run by a private agency, and therefore there is more flexibility than the government-run agencies. FDS is used in some courts in Whatcom County, but not in Skagit County. Work crew is used in Whatcom County quite a bit and might be used in lieu of jail if the jail isn't mandatory. Work crew is usually manual labor and involves yard work in parks like raking leaves, mowing lawns, or picking up garbage in local parks or alongside highways. Community service can be negotiated with prosecutors in lieu of jail, but honestly, we don't seem to see a lot of community service in DUI cases. A scram bracelet is an ankle device that detects alcohol consumption through sweat glands. These devices may be ordered at your first court date if the facts of your case are extreme or if you have prior DUIs. In my jurisdiction's Bellingham Municipal Court loves scram bracelets, so be duly aware. If you're convicted of DUI or reckless driving in the court system, you will lose your license. The court does not suspend your license, but sends information regarding the conviction to the DOL. The DOL then suspends your license, and you'll receive confirmation of the suspension approximately 2 weeks after your plea. The suspension will likely not occur until around 45 days or so after the final court date. If you had a Department of Licensing hearing and lost, you will receive credit for the time you've already served. All right, I do spend a lot of time talking about reducing a DUI throughout this video, so I think it's appropriate I talk about the most common reductions from DUI. And I won't talk too much about what a DUI is and how the state needs to prove it and so forth. That's actually for a different video. But suffice to say, a DUI can be proven if the defendant has a blood alcohol concentration of 0.080 or higher within 2 hours of driving. And this is called, by the way, a per se DUI. Or if the defendant has 5 or more nanograms of THC, which is marijuana, within 2 hours of driving, or if the defendant is impaired by alcohol, drugs, or a combination of alcohol or drugs. Reckless driving is a common reduction from DUI, and like a DUI, it's also a gross misdemeanor. But unlike a DUI, it has far fewer penalties. In fact, the only penalty that is mandatory with reckless driving is a 30-day license suspension. Negligent driving first degree is even better than reckless driving. Neg 1, as we call it, is a simple misdemeanor and has no mandatory penalties. Do you want your DUI and every accompanying charge to be dismissed? Do you want to avoid all jail time and home detention? And do you want to save your license from suspension if you gave a breath or blood test? Well, you can. You can do all of these things, in fact, if you successfully enter and complete the Deferred Prosecution program. Deferred Prosecution permits those who are alcohol or drug dependent or suffer from mental health issues to enter into a 2-year treatment program in exchange for a complete dismissal of the charge or charges in 5 years. Also, this results in no jail and no loss of license if you gave a breath or blood test. The Deferred Prosecution statute allows you to petition or ask the court for a deferral or postponement of your case for a period of 5 years while you seek treatment for your dependency problem. If you petition the court and it's granted, the advantages are obvious. You keep your license, avoid a conviction, avoid being fined, and except for cases of where those charged refused the breath or blood test, avoid an administrative license suspension. To qualify for deferred prosecution, you must obtain an evaluation from a state-approved treatment agency. The treatment facility will conduct a detailed assessment, and if it concludes that the criminal conduct was the result of alcoholism, drug addiction, or mental health problems, and that you're amenable to treatment, meaning that you're serious about treatment and willing to be treated, you are eligible for deferred prosecution. Presuming that you've never been granted a deferred prosecution before. You're only permitted one deferred prosecution per lifetime. Now, if you're considering entering into the deferred prosecution program in Washington, it's critical that you and your attorney be familiar with the court where the petition or deferred prosecution will be entered. The program consists of a required 2-year treatment program, which is broken down to a demanding 3-phase schedule. The first phase is typically 3 nights per week for the first 2 or 3 months. Phase 2 involves 1 meeting a week for a 6-month period. Phase 3, which is the least rigorous of the 3 phases, requires counseling once a month for the balance of the 2-year program. You'll also be required to attend 2 self-help meetings, like Alcoholics Anonymous, for 2 years. Those who choose the deferred prosecution option are then placed on supervised probation, which requires a monthly meeting with the probation officer. Additionally, an ignition interlock device will be required for at least a 1-year period. If you submitted to a breath or blood test, a deferred prosecution will save your driver's license. Now, if you do everything correctly, your DUI and any accompanying charge will be dismissed 5 years from the date of entry, or 3 years after treatment has concluded, whichever is longer. If you are considering doing the deferred prosecution program, you should take it seriously, obviously. This program is not for the faint of heart, and failure will bring dire consequences as the court demands strict compliance. Okay, a couple of recommendations. Talk this through in detail with your lawyer. Similarly, talk this over thoroughly with your loved ones. And also weigh up the benefits and the burdens. If the burdens, for example, are more than the benefits, don't do it. And if the opposite is true, that is, the benefits are bigger than the burdens, then perhaps this is the right program for you. Now, there are some things that you will be required to do during your case that are very important. These include an alcohol drug evaluation, the possibility of alcohol or drug treatment, an ADIS class, and the DUI Victim Impact Panel. I also advise my clients to complete these requirements prior to the conclusion of the case, as it may help improve the case. However, you should only proceed with these after consulting and being counseled by your own attorney. An alcohol drug evaluation is a structured assessment used to determine an individual's substance use history, patterns, and potential impact on their life. It typically involves a clinical interview, standardized screening tools, and biological testing. In other words, a urinalysis. Following the evaluation, the treatment counselor will provide a diagnosis. The diagnosis will determine if you have no significant problem, the potential for abuse, or a significant problem with a substance that requires treatment. The Alcohol Drug Information School, also known as the ADIS class, is an educational program designed for individuals with substance-related offenses or concerns. It covers the effects of alcohol and drugs, legal consequences, and responsible decision-making. Alcohol and drug treatment is a structured program designed to help individuals overcome substance use disorders. It might include detox, counseling, behavioral therapies, and support groups offered inpatient or outpatient settings. Treatment addresses physical, psychological, and emotional aspects of addiction, aiming for recovery, relapse prevention, and long-term sobriety. The DUI Victim Impact Panel is a program where individuals hear firsthand accounts from victims or their families about the consequences of impaired driving. It aims to increase awareness, promote accountability, and reduce repeat offenders through emotional, real-life testimony. Probation is very important, and if at all possible, best to be avoided. Let's talk probation. Probation usually follows the completion of the case. Now, there are two types of probation: active or supervised. They're the same thing. This is when you report directly to a probation officer, are subject to random urinalysis testing, and you'll pay a lot of money for this privilege. Right now, that amount is as much as $100 per month. The other is inactive, or also called unsupervised probation. This is when you do not report to a probation officer, are not subject to urinalysis random testing, and you will pay much less, at least in Whatcom County, or you'll pay nothing, as in the case in Skagit County. Now, I take the negotiation of probation very seriously, and any way we can possibly reduce probation is worth exploring. Okay, here are a few tips when preparing for or dealing with probation. First, follow the direction of your attorney during the case, and what I'm really referring to here is the completion of an alcohol drug evaluation, the recommended treatment or classes, and the DUI Victim Impact Panel. In many courts, the completion of these required tasks will allow us to negotiate unsupervised probation. Now, if you are on probation, do everything you can to make the probation officer happy. If they're happy, you're happy. Do not miss meetings, do not drink or use drugs, and remember, they will be testing randomly, so be careful of that, and also do not commit any new crimes. And if you do all of these things, you should be fine with probation. Now, what if you miss a meeting, admit to consuming alcohol or drugs, or test positive for these things, have a positive ignition interlock device reading, or are charged with a new criminal offense? Well, clearly this is not very good. However, if any of these alleged violations occur, the first thing you should do is call your attorney. Do not wait until the last minute to do this. But if any of the violations are alleged, you'll be heading back to court and you'll need to address these issues with the judge. If you're convicted of DUI, some violations are very serious. For instance, if you drive without valid insurance, without a valid driver's license, or drive without an ignition interlock device when you're required to have one, the mandatory penalty, if you were convicted of DUI, is 30 days of confinement. Yes, 30 days confinement does mean jail. Your license is important, and losing it may not be an option. As a result, it's very important you do everything you can as soon as you can to give yourself the best chance of prevailing and keeping your ability to drive. Now, that being said, you'll be dealing with the Department of Licensing, the government, and I don't even know where to begin with them except to say, expect the licensing part of the DUI to be difficult, painful, and frustrating. Yes, we do in hearings, we do save licenses, but the government has the real advantage here. And I'll discuss that a little bit more in a moment. The first thing you must do, though, is really important. You must request a Department of Licensing hearing within 7 days of the arrest date. This time requirement might change if there's a blood draw, for example, but this is the rule if you have a breath test, a BAC test, or if you refused the breath or blood test. Because we have this very strict timeline, it's important you react right away, and another good reason to consult immediately with a lawyer. Now, to apply for this hearing, you must either send in the form that law enforcement should have provided you, or you could apply online. Now, I do recommend applying online as the system seems to work quite well. It once upon a time didn't, and it does expedite the process. If you prefer to do it by mail, which is mailing in the application you were given, be sure you mail it by certified mail. Now, if you do nothing, your license will be suspended about 30 days from the date of violation. If you do request a hearing, your license suspension will be stayed, which means put on pause, and you'll be okay to drive until a result comes from the hearing. The hearing will be set about 30 days from the date of the incident. You'll hear back from the Department of Licensing about 2 weeks or so after you have requested the Department of Licensing hearing. All right, let me get something out of the way right away. These hearings are tough. They're hard to win, and the DOL will readily tell you just that. In fact, it's all searchable information. Truth is, the majority of people lose these hearings, which sounds really negative, but it's also true, and we want to get that out of the way and be transparent as much as possible. However, the way I look at it is this. You have no chance if you do not request a hearing, and you have a chance if you do. So really, as with most things in life, it comes down to money. These hearings are not cheap. It'll cost you $375. Now, there are times when requesting a hearing does not make sense, and that sometimes comes down to the facts of your case and your financial situation. If the facts of your case do not look favorable, either at the Department of Licensing hearing or in court, then your attorney may discuss the validity of doing the Department of Licensing hearing. Collectively, you might decide it's not worth it, but this discussion should be had with your lawyer. The second reason you might not want to do the Department of Licensing hearing is if you're seriously considering doing a deferred prosecution. If you do a deferred prosecution, you can save your license from suspension unless you refused a breath or blood test. However, if you gave a breath test, then you can save your license by filing an intent to seek deferred prosecution within 30 days of the date of your arrest. The deferred option will not, however, save a CDL. Finally, the Department of Licensing hearing might not make sense if the $375 is not financially possible. If that's the case, you can file the request for a DUI DOL hearing and file a fee waiver. Of course, you'll need to complete the form, and the Department of Licensing will ultimately decide if you qualify for the fee waiver. Once you've requested the hearing, you will receive a notice for the date of the hearing. The hearing will be set within about 30 days of the date of the arrest. This hearing can be continued, which means changed to a future court date if your attorney believes it's in your best interests. Okay, what is this hearing all about? Well, first, it's not a criminal hearing. It's an administrative or civil hearing. This means there are different rules, and these rules are much more relaxed than in court. Also, the DOL hearing is telephonic. It's on the telephone and not in person. You can choose to be present by phone, but equally, you do not need to appear at this hearing so long as your attorney does. There are 4 main issues to be decided at this hearing. First, was the original stop of your vehicle or contact with you lawful? Second, was there probable cause to arrest you for DUI? Third, were the implied consent warnings read to you and done so correctly? And finally, was the breath or blood test valid, or was the refusal of the breath or blood test valid? And while there are some procedural issues to be considered too, those 4 issues, that's it. We're limited with what we can argue. The rules are very relaxed. The government does not need to prove very much. And finally, you're asking the government to rule against the government. All right, well, the reality of getting a DUI charge is that there is a possibility, a very real possibility, of a license suspension. And the government makes sure of this likelihood by coming at you twice. The first is administratively. You will in fact lose your license 30 days after your arrest unless you appeal the license suspension and, of course, win. Now, the second way you can lose your license is if you're convicted in court of either a DUI or reckless driving. The restricted license is a license that permits you to drive even though you are suspended. Confusing? Yes, but the good news is that if you do receive a suspension, you do have an option to keep driving and keep being mobile. The available restricted license is called the Ignition Interlock license. The license requires an ignition interlock device, SR22 insurance, and the $100 application fee. Do not forget that this type of license is only eligible for the time of suspension, and once the suspension is over and you're eligible for reinstatement, you must reinstate your license as this restricted license is no longer valid. If you have received a suspension, once the suspension is over, you must then reinstate your driver's license. It does not automatically reinstate itself. Check with the Department of Licensing what they need, but typically they will need on file proof of SR22 insurance and a reinstatement fee. Now, depending on the outcome of your case, they may also need proof of installation of the ignition interlock device. If in doubt, ask your attorney or the Department of Licensing. If you're concerned about the validity of your license, you can check your license status online with the Department of Licensing, and it will tell you in real time if your license is valid or if it isn't. The ignition interlock device is another example of a good idea that is poorly executed. An ignition interlock device is a breathalyzer installed in a vehicle that requires the driver to blow into it before starting the vehicle or driving. If there is alcohol detected and that level is too high, the engine will not start. These devices also require a breath sample while driving. Sounds safe, right? Yeah. Well, the problem is these systems are fickle and sensitive. Once again, knowledge is invaluable. When you have one installed, ask the installer every possible question you can think of. And here are a few tips. Do not drink or eat anything within 20 minutes of driving. And this is most especially important when it comes to things like mouthwash. Do not drink or eat anything in the car. Now, there are too many drinks that might cause problems, such as fruit juices, kombucha, obviously, and even energy drinks. Yep, looking at you, Red Bull. There are some food products that can actually cause you problems too, like breath mints, gum, spicy foods, and food with yeast. Do not let anyone play with a device. This is not a toy. and can land you in trouble if there's a violation. Do not warm up the car and leave it running. The ignition interlock device may request a breath sample while the vehicle is running and warming up. And guess what? You will be in the vehicle to give it one. That's a violation. If you have problems providing a breath sample and the device times out, do not leave your car. Wait until you're able to blow again and then provide a valid breath sample. If you abandon the vehicle, many people, like a probation officer or a judge, will think that you caused the violation. And finally, and oh so importantly, do not remove the ignition interlock device until the DOL says you're okay to do so. The DOL requires a certificate of compliance from your ignition interlock device provider. This states that the final 6 months of required installation has been without user error. You cannot remove the ignition interlock device until the DOL has received and accepted this document. If you remove the ignition interlock device early, you'll have to reinstall it and keep it in your vehicle for another 6 months. All right, and finally, one of the reasons I have a problem with this device is because the technology is archaic. It's very old. You don't know who's used it before you. It's not a new product. You're getting a product that might have been used for many years. It's not a product out of the box. You're leasing it. So you do not know the history of this older device. And to give you an example, this is a beautiful old camera. I think it's from the 70s. It's a film camera. And the pictures it produces, oh my word, they're terrible. On the other hand, we have, an iPhone. It's accurate, it's sharp, it's consistent, and it's reliable. This is not your ignition interlock device. This is your ignition interlock device. The certificate of compliance is the document submitted by your ignition interlock device vendor to the Department of Licensing at the end of your ignition interlock device requirement period. When you're finished with your requirement period, contact your ignition interlock device vendor, the installer, to request the certificate of compliance. They'll submit the certificate of compliance if you have not violated any of the required conditions in the last 180 days. These conditions include attempting to start the vehicle with a breath alcohol content of 0.04 or more, failed to take or pass any required retest, failed to schedule maintenance for your ignition interlock device, such as repairs, calibration, monitoring, inspection, or replacing the device. If you violate any of these conditions, you'll need to restart your certificate of compliance time period, which is for another 6 months. And another word of advice, do not remove the ignition interlock device until the Department of Licensing confirms they have this certificate on file. SR22 insurance is a certificate that proves that you, the driver, carries the required minimum liability coverage. If you lose your license, you will be required to have SR22 insurance for a period of 3 years. If you operate an employer-owned vehicle during work hours, you can submit an employer declaration that will allow you to drive the company vehicle without the ignition interlock device. Now, of course, there are many rules, including that you can only use it for work and you're not permitted to drive the vehicle, the company vehicle, to and from work. And you must carry a copy of this waiver with you whenever you drive the company vehicle. If you're required to have an ignition interlock device, but you're unable to use it because of medical issues, such as not being able to provide enough air for the device, you may be eligible for an ignition interlock device medical exemption. However, you won't be able to drive during this designated time at all. But you do get credit for the time towards the ignition interlock device required time period. And when the time period is over, you will then be able to drive. It's a little bit confusing, so before you go through that process, I highly advise you talk it through with your lawyer. A DUI has severe consequences for a commercial driver's license or CDL holder. even if the offense occurs on a personal vehicle. A first DUI conviction typically results in a 1-year CDL suspension or 3 years if you're transporting hazardous materials. A second offense often leads to a lifetime disqualification. CDL holders also face higher insurance rates, job loss, and difficulty finding new employment since most trucking companies have zero tolerance policies. All right, choosing an attorney. Now, this is obviously a very important discussion. And yes, there are some basic qualities that you should look for when choosing an attorney, and they include. Now, the attorney doesn't need 30 years of experience, but they do need enough experience to have done hundreds of DUI cases and dealt with all sorts of legal issues in court and with the Department of Licensing. And only experience can do this. So then, how much experience is enough? Well, it's tough to answer, but honestly, I would say from experience that no less than 10 years and at least 5 years of focused DUI defense. More is always better, but this should be a minimum. DUI law is very technical and complicated, and there's really so much to know. It's not simply about putting on a suit and going into court. The number of statutes that we need to know is significant, mind-boggling actually, and we also have to know hundreds of different legal cases and have a thorough understanding of the Department of Licensing, which by itself is awfully confusing. If an attorney isn't fully invested into this area of law, it's hard to have a complete grasp on everything. I don't think a lawyer needs to only do DUI law, by the way, to be good, but I do think the majority of their cases have to be DUI defense cases. Having good staff might be the difference between a good law firm and a great law firm. If you talk to a staff member when you're looking for an attorney and they're rude, unpleasant, or know very little about DUI law, hang up and move on. Staff are important and complement the lawyer. Now, I'm so lucky that I have probably the most overqualified paralegal in Washington State in this area of law. Janine has her master's degree, is fully trained in field sobriety testing, the same as the officers, and has been doing this for over 20 years. Be careful if you're hiring a law firm that has associates. Now, I will say there's some very good associates out there, so there are many exceptions. However, no associate cares as much about your case, generally speaking, as the main attorney. Why? Well, their name isn't on the door. Their reputation isn't at risk. And also, associates do not have the same experience as the owner. You don't want to have an associate represent you who only has a few years of experience and is learning the craft thanks to you. So it's important to ask a prospective lawyer who is going to work on your case. If it isn't the attorney you're speaking with, move on. Reputation is almost impossible to know if you're looking for an attorney. So this is a tough one. However, reputation is critical. It makes negotiating easier. Judges have more trust and respect in your lawyer, and the same is true for court clerks. Often referrals are a good way to measure reputation too. Another good way potentially to measure reputation is to see what this lawyer has done in the DUI defense space. If they have spoken on the subject, produced helpful videos that help more than just their own clients, written books and pamphlets on DUI law, then it's probably fair to say they have a decent reputation for having a good knowledge base, and that's always a good place to start. I can't emphasize how important it is to be local and to know the local court system. Knowing the prosecutors, the judges, probation officers, local jail staff, local rules and practices, or even the local troopers and officers is absolutely necessary for excellent representation. Now, this is part of the package, honestly, that you're buying. And if they're not local, then you are now at a disadvantage. So if you're looking for a DUI lawyer and you rely on Google search, be careful, because right at the top of that Google search page is advertising. And you'll often see lawyers from different counties far away advertising. They probably don't have offices in Skagit or Whatcom Counties if you're looking for a lawyer in one of those two counties. They might be in Seattle or Snohomish County. Now, they also often appear at your court appearance by Zoom and not in person. How do I know this? Because I'm in court and I see them on Zoom all the time. Also, they do not know as much as a local attorney about the local court system. And guess what? You'll pay more and get less. So I can go on and on about this, but your goal in getting an attorney is to give you every advantage in court. Hiring someone who knows less about the local court system and legal process is not working towards that goal. So I do have a thing or two to say about public defenders. Now look, if you're unable to afford a private attorney, and yes, private attorneys are not exactly inexpensive, you may qualify for a public defender. I do hear negative things said about public defenders, and I have this to say. They have a very difficult job. They are well trained, and they will likely give every ounce of their being to you because they got the job because they really believe in what they do. The truth is they do have way too many cases than they really should have. Probably hundreds and hundreds of cases per public defender. And because of that, you cannot expect them to even spend a portion of the time that a private attorney like myself would on an individual case. The other thing, too, is they're not DUI-focused attorneys. DUI defense is very specific, so the more you know and the more focused you are, the better. And finally, public defenders do not do Department of Licensing hearings. Being charged with a DUI can have significant collateral consequences beyond just the legal penalties. These can impact various aspects of life, including employment, finances, personal reputation, and travel. A common question I get is, how will a DUI affect your employment? So this is actually a very difficult question to answer. My first response and most honest response is, if there's any risk of employment, you should immediately speak with an employment lawyer. Not that anyone really wants to speak to yet another lawyer. My second response is, if you're part of a union, go talk to your union representative. A DUI charge or conviction can significantly impact jobs regulated by the Federal Aviation Administration, otherwise known as the FAA. The FAA has strict reporting requirements and consequences for aviation professionals. As always, take this information only as a guide and not legal advice, and I do recommend contacting a lawyer with experience with the FAA. Pilots must report a DUI charge, conviction, or administrative license suspension within 30 days under 14 CFR 61.15. A DUI can trigger a review of the pilot's medical certification, potentially leading to denial, suspension, or revocation. Airlines and corporate aviation companies have strict policies regarding DUIs and may terminate or suspend pilots. A DUI may lead to a medical disqualification or a required evaluation by the FAA Office of Aerospace Medicine. The FAA or employers like the Federal Aviation Administration Air Traffic Organization may suspend or terminate air traffic controllers with a DUI. Now, this is obviously concerning on many fronts, including the fact that we have too few air traffic controllers to begin with. Those holding an airframe and power plant certification must comply with FAA regulations, and a DUI may lead to additional scrutiny. Many aviation maintenance jobs require security clearance, which could be affected or jeopardized by a DUI. Like commercial pilots, flight instructors must hold a valid FAA medical certificate, which a DUI might jeopardize. Flight schools and training organizations often have strict policies regarding DUIs. The bottom line is anyone in an FAA-regulated role should take a DUI charge very seriously. Immediate reporting and compliance with FAA guidelines are crucial to maintaining certification and employment. The military. A DUI in the military can lead to a non-judicial punishment, Article 15, court-martial, rank reduction, fines, or even discharge. It may also result in loss of security clearance, restricted promotions, and denial of reenlistment. A DUI can also limit deployments, disqualify service members from certain roles, and damage their careers and reputation. If you are charged with a DUI and you're in the military, be sure you understand the reporting requirements. But typically, you must report the DUI immediately upon release. A DUI conviction can make a U.S. citizen inadmissible to Canada, as Canada treats DUIs as serious criminal offenses under its immigration laws. To make matters worse, since late 2018, Canada also restricts entry if the DUI was amended to either reckless driving or negligent driving in the first degree. And finally, Canada treats a deferred prosecution like a DUI, so a deferred prosecution will not permit entry either. Options to overcome inadmissibility include the temporary resident permit, otherwise known as a TRP, criminal rehabilitation for older convictions, or deemed rehabilitation after 10 years. Again, if you want to explore the possibility of visiting Canada after a DUI conviction or reduction from DUI, contact a Canadian immigration attorney. Now, other countries may deny entry because of a DUI as well, but this is a relatively fluid area of law and could change at a moment's notice. So my recommendation is check with the foreign country's consulate, as they often have helpful information. What I do know is that travel to Great Britain and the EU does not seem to be impacted by a DUI conviction. For now. One of the biggest collateral consequences of a DUI charge is the emotional toll. You may go through every emotion from anger to guilt to eventually some form of acceptance. Regardless, it's not easy, and I hear the stress from my clients every single day. The first thing is, you're okay, and I hope everyone else also that's involved is okay. And if everyone is okay and there's no other significant injuries or any injuries as a result of the DUI, then that is the most important thing.